Blog Talk Radio.
Welcome to Family Law Talk.
Family Law Talk.
Presented by Kirk Stange of Stange Law Firm, PC. Stange Law Firm is a family law firm with offices in Missouri and Illinois. Now, here's your host, Kirk Stange.
Welcome to Family Law Talk. We have an interesting topic today. The topic is marital misconduct and divorce. It's an important topic, one that clients have lots of questions about when they're going through a divorce. And this is based on an article on familylawheadquarters.com dated September 6, 2015. So as a follow-up to the episode today, go to familylawheadquarters.com and you can check out the article titled, What Effect Does Marital Misconduct Have in a Divorce? And that would be a good follow-up to the topic here today. But again, here's the topic, and the topic involves marital misconduct and divorce. And the question lots of folks have is, does marital misconduct matter anymore? Is it something that the court takes into account in regards to the resolution of the case? And then some folks still wonder whether or not they need to prove marital misconduct in order to get divorced. And so that's a question individuals have as well. And obviously the laws vary by state. There's specific nuances, specific differences in various statutes across the states regarding exactly how this works. So it's important that you definitely check with a family law attorney in your state to figure out what the laws are, what effect marital misconduct may or may not have in your case, because again, this can vary. All of that said, New York in 2010 adopted no-fault divorce, and I'm not a New York attorney, but that's my understanding, that New York adopted no-fault divorce in 2010. And so with that move, it is now uniform throughout the states that, you don't have to prove fault to get divorced. And so again, there's specific nuances, specific differences in the various states out there. And I'm an attorney in Missouri, in Illinois is where I primarily practice, and this is where our firm has offices is in Missouri and Illinois, and the reality of the situation here is this: is in Missouri and Illinois, and again there could be different nuances between the states in terms of how this is exactly worded, but in a general sense, if both parties agree that the marriage is irretrievably broken and there's no reasonable likelihood that it can be saved, and again this can be worded slightly different. Then from there, a court can grant a divorce and almost always does. There's some specific differences. In other words, in Missouri, there's a 30-day wait period still from the day that the case is filed to the day, at the end of the day, that the court can grant the divorce. And then in Illinois, there's been some new changes to the laws, which are going to take place next year, where even where the parties agree that the marriage is broken, irretrievably broken, they want to get divorced, there's a separation period that still has to be met in order for a court to grant a divorce. And that period has changed and gone down to 6 months, which is the parties have to be separated for 6 months. But that said, past the waiting period in Missouri and the separation period in Illinois, which will go into effect next year, which went from 2 years down to 6 months, parties don't have to prove fault in order to get divorced. And so what is fault? Well, fault could be lots of different things historically. If you study, the way courts handle divorce proceedings through the years, fault can be cheating or an affair. It could be abuse of some kind, domestic violence. At the end of the day, it could be abandonment, where one spouse picks up and leaves, doesn't return. It could be a situation of financial misconduct of some kind. Could be like gambling, for example. And there's various other conduct that a court could have considered fault as well. And so historically, before the advent of no-fault divorce, what folks typically had to show, and again, the laws varied by state, right? So there's specific nuances, and I'm very much generalizing. But historically, what folks had to show was some kind of fault to get divorced, just alleging that the marriage is broken, irretrievably broken, and that the parties at the end of the day aren't in love anymore and don't want to be married. That wasn't enough. There needed to be fault proven. And so with the advent of no-fault divorce, you strip that out, and if both parties agree that the marriage is irretrievably broken and there's no reasonable likelihood it can be saved, then at the end of the day, folks can get divorced. Again, in Missouri, you got a 30-day wait period. Over in Illinois, the law's changed, but now the parties need to be still physically separated for a period of 6 months. And so with all of that, people hear no-fault divorce, uncontested divorce, this kind of terminology, and lots of folks still wonder what role fault still has in divorce proceedings. Some individuals, when they hear this concept of no-fault divorce or uncontested divorce, they assume that fault now has no bearing whatsoever on the outcome of a divorce, and they think it's completely irrelevant. Some individuals, on the other hand, are still very interested in terms of looking into fault during the marriage, in terms of putting evidence on at a trial or a hearing to the court to show that their spouse maybe acted wrongly during the marriage, acted in a way that they think is unacceptable, and they're still interested in pursuing this information and putting this information on to the court with the idea that somehow it's going to affect the case in a way that's beneficial to them and maybe to others. They feel as if just bringing this out into the open allows them to move on, I guess, in some ways. And so, maybe it doesn't ultimately affect the outcome. It allows a party sort of figuratively to move on with their life. And so you get kind of caught in this quandary. So the issue is with the advent of no-fault divorce, does fault matter anymore? Is it worth the time? Is it worth the energy? Is it worth the fees that one might incur to try to put evidence on a fault, and can this even be admitted in court at all? In other words, does a court even allow this kind of testimony? And again, I'm going to speak very generally because the laws in each state, again, can vary, and different judges can rule differently in different jurisdictions, and obviously, facts of cases can be different, which can lead to definitely different results. Again, I'm going to speak very generally, and it's important to speak with an attorney about your specific situation to try to determine how your case might specifically play out. But here's the deal, which is while you don't have to prove fault to get divorced in Missouri or Illinois, in Missouri, interestingly, when the court, at the end of the day, divides property and debt, in Missouri, the law indicates that the court is to divide marital property and marital debt, which is property accrued during marriage, which is not separate, in a just manner when considering various factors. Now, there's various factors that the court can look at in making a just division, but the one we're going to talk about today, just for purposes of this episode, is the conduct of the parties during the marriage. And so the Missouri statute indicates that the court still, in dividing marital property and marital debt, can consider the conduct of the parties during the marriage. That's interesting. And so that, in a lot of ways, brings the potential for conduct to come back into a case, even when conduct doesn't need to be shown in order to get divorced. So theoretically, a court could not like the conduct of one of the parties and theoretically decide not to divide the property in an exact 50-50 manner because the court is displeased with the conduct of one of the parties during the marriage. So it's one of the factors. Now, there's multiple other factors. It's just one of the factors. And again, the court doesn't have to consider it at all. A party can attempt to put evidence on about conduct, and the court ultimately might not be swayed to deviate from some, a 50-50 property division or whatnot based on conduct. But the court has some ability to look at it and make a finding in terms of conduct of the parties, and the court could consider it ultimately in Missouri. Interestingly, over in Illinois, the statute's the opposite, which is the court is not to consider the conduct of the parties if you read the plain language of the statute in terms of property and debt division. So again, you see a difference between Missouri and Illinois. Missouri, conduct of the parties during the marriage, one of the factors. In Illinois, the statute excludes conduct of the parties. So that's interesting, which again I think plays to the differences between the states in terms of how this can work. In terms of spousal maintenance, Missouri, Illinois, differences in the statutes, differences in the language, but overall kind of similar concepts in a lot of ways, although Illinois has changed things to have a more specific formula if the party's income is under a certain threshold in terms of maintenance, which is this new maintenance law that went into effect over in Illinois, which is really interesting. But to not get too specific there and just compare Missouri and Illinois in terms of conduct of the parties, the court looks at the reasonable needs of the parties in assessing maintenance in Missouri, and looks at the reasonable needs and the income of the party seeking maintenance. Also looks at the reasonable needs and the income of the party, the other party who's not seeking maintenance theoretically, but the party who's being asked to pay maintenance by the other spouse. And so the court looks at both the parties and then looks at various factors. And there's all kinds of factors the court can look at, like length of the marriage, obviously the standard of living during the marriage, and there's multiple factors. But again, the one factor I want to focus on here today is the factor of the conduct of the parties during the marriage. The Missouri statute allows the court to look at that one factor along with various other ones. So theoretically in Missouri, the conduct of the parties during marriage could affect a maintenance case. Doesn't have to. It could be that the judge completely disregards it. It could be that the court is swayed based on the conduct of the parties during the marriage in terms of a maintenance award. But at the end of the day, again, it gives the court the ability to look at it. Over in Illinois, it's excluded again. So in determining spousal maintenance in Illinois, it's excluded from the statute. So in Illinois, courts aren't supposed to consider the conduct of the parties during the marriage and making a maintenance determination. And then finally, let's talk about the issue of child custody. Obviously, in child custody cases, courts to look at the best interest of the child when considering, various factors again. And the court can look at all sorts of different things. Generally speaking, conduct of the parties that doesn't affect the kids, that doesn't impact the kids' best interest and well-being. Generally speaking, this won't have an effect on a custody decision, but it could be a situation, theoretically, with a new, let's say if it's cheating or an affair, the new boyfriend or girlfriend. Let's say they have a checkered past. Let's say they've had some sort of criminal problems in the past. Let's say maybe they've been abusive to the kids in some manner or capacity. Could a court take that into account in Missouri and Illinois in determining custody? I mean, theoretically, yes. In some instances, if one party picks up an lease and abandons the household and the kids, could that have an effect on child custody? Yeah, I mean, in Missouri and Illinois, that could be one factor a court could look at. And then you could follow that in terms of financial misconduct. Let's say one of the parties has a gambling problem and they're gambling away a lot of money and they're not home with the kids. Could that be a factor in determining child custody? Theoretically, it could. And so in Missouri and Illinois, conduct of the parties, if it impacts the kids in a way that affects the well-being and best interest of the kids, it can be a factor that the courts can look at. And so that would be the case in Missouri and Illinois. And again, it's important to look at the state statutes in which any listener is living in for their specific situation in order to get guidance. But again, this is the topic in terms of marital misconduct and divorce. Definitely an interesting topic. And while marital misconduct doesn't need to be shown in order to get divorced, at the end of the day, you see variances between Missouri and Illinois. But the important thing to note is that in some states, marital misconduct can still have an ultimate impact on the outcome while not needing to be shown in order to get divorced. So it could affect property and debt division. It could affect spousal maintenance theoretically, and it could affect child custody based on the facts as well if there's an effect on the kids. And so it's important that, if you think marital misconduct is a big issue in your case, you have a great deal of concern about it, it's definitely important to consult with an attorney who's licensed and competent to practice in your jurisdiction to discuss what the ramifications of that marital misconduct might be. So definitely an interesting topic. Again, as a follow-up to the episode, go to familylawheadquarters.com and check out the article dated September 6, 2015, titled, What Effect Does Marital Misconduct Have in a Divorce? Thanks for tuning in. Stay tuned to our next episode coming up. Thank you very much.
Thank you for listening to Family Law Talk.
Family Law Talk
with Kirk Stange. Visit StangeLawFirm.com for more about today's topic or to put Stange Law Firm to work for your family today.
The choice of a lawyer is an important decision that should not be based solely upon advertisements.
Neither the Supreme Court of Missouri or Illinois reviews or approves certifying organizations or specialist designations. The information you obtain on this podcast is not, nor is it intended to be legal advice. You should contact an attorney for advice regarding your individual situation. We invite you to contact us and welcome your calls, letters, and electronic mail. Contacting us does not create an attorney-client relationship. Please do not send any confidential information to us until such time as an attorney-client relationship has been established. And finally, past results afford no guarantee of future results, and every case is different and must be judged on its own merits.
Kirk Stengey is responsible for the content. Principal place of business, 1750 South Brentwood Boulevard, Suite 401, St. Louis, Missouri, 63144.
Did you miss your deadline to renew your Medicaid coverage? You can still send your completed annual review form to Healthy Connections Medicaid. You may be assigned to another health plan, but you can ask to come back to First Choice within 60 days of renewed Medicaid eligibility. It's your family. It's your choice. First Choice is the right choice. Renew and choose us. Visit selecthealthofsc.com/renew to learn more.
Why don't more infant formula companies use organic, grass-fed whole milk instead of skim? Why don't more infant formula companies use the latest breast milk science? Why don't more infant formula companies run their own clinical trials? Why don't more infant formula companies use more of the proteins found in breast milk? Why don't more infant formula companies have their own factories instead of outsourcing their manufacturing? We wondered the same thing. So we made ByHeart, an infant formula company on a mission to get a lot closer to the most superfood on the planet, breast milk. Our patented protein blend has more of the important and most abundant proteins actually found in breast milk. We're the first and only U.S.-made formula to use organic, grass-fed whole milk, not skim. We even conducted the largest clinical trial by a new infant formula company in a quarter century, with clinically proven benefits like easier digestion, less spit up, and softer poops versus a leading infant formula. And we make our own formula in the USA and our very own factories in Iowa, Oregon, and Pennsylvania. ByHeart, a better formula for formula. Learn more at byheart.com.